We need to have a serious conversation about access to justice in America because poor people cannot afford a lawyer. Working people cannot afford a lawyer. Middle class people cannot afford a lawyer. Upper middle class people cannot afford a lawyer. The reality is that unless we are talking about a contingency fee case, and folks need to get real about a contingency fee case. I can't even begin to count the number of times over the past decade that Joe Schmo has showed up and said, oh my God, I've got the greatest case ever, and you should take it on a contingency fee and make a name for yourself, right? That's my favorite, right? Make a name for myself. But unless we're talking about a case that really fits on a contingency fee model, and let's sort of map that out for a second, right? What types of cases fit on that model? Well, personal injury case, right? Where there's an insurance policy on the other side. You know, there's virtually guaranteed to be, it's not guaranteed, but there is, you know, overwhelmingly more likely than not to be some kind of payout on the other side because there's an insurance policy and there's an insurance carrier. And ultimately, at the end of the day, you know, they're going to assess, okay, there's some settlement value here and they will pay something to get rid of it, right? But that's not available in many other contexts, and particularly it is not available in non-personal injury sort of, you know, civil litigation, right? Somebody gets sued for a non-compete agreement. Somebody gets sued for theft of trade secrets, right? Somebody gets sued for trademark infringement, right? So America of the past, right, many decades ago, America was supposed to be all about robust competition, right? May the best person win, may the best company win, right? And over several decades, America has morphed into this massive antitrust collusion and suppression of competition problem. And we see that nowhere more acutely and directly than in the context of abusive non-compete agreements, right? The rampant overuse and misuse of non-compete agreements in the labor market as a tool for, one, restraining employee mobility, two, preventing competition for employee talent, and three, ultimately suppressing wages. And unfortunately, and this is going to offend a lot of people, and I'm sure somebody will bar complaint me for it as they do, but the courts and the judiciary have unfortunately been complicit in this. And I will tell you how they've been complicit in this, right? So people will take advantage of any system that exists, right? If there's an advantage that can be taken, people will take that advantage, right? It's basically the sort of, you know, it's the sort of wicked underside of human nature, right? If you set up a system, okay, and it can be taken advantage of, somebody will take advantage of the system, right? And so that's how sort of non-compete law has worked, right? There's this system where, you know, it's supposed to be okay. Non-compete agreements are restraints of trade. They're subject to antitrust scrutiny. They're only to be enforced in the most limited circumstances, only where it's very compelling. There's legitimate business interest. There could be irreparable harm, etc. You know, this is supposed to be 1 out of every 100, right, at most. But now instead, in certain jurisdictions throughout America, particularly in Florida and, you know, in Texas and a couple of other places, it's basically like, you know, they give out non-compete injunctions like candy, right? They, of course, just hand these out, right? Where it's like, okay, you came into court, you know, you got your non-compete agreement, you asked for your injunction. Well, you know, that's what we do around here. Here you go. Here's your injunction. And that is not how the law was ever intended to work. And think about it, right? Non-compete agreements, restraints of trade, they are supposed to be the exception to the rule, right? Rather than be the rule. They were supposed to be, sort of unique, extraordinary, special circumstances rather than be the vast majority of circumstances. And that's what we have now, right? Where non-compete agreements are ubiquitous throughout the labor market, particularly in states that are pro-non-compete agreement, which to a certain extent, Florida is a pro-non-compete. It's an aggressively pro-non-compete jurisdiction. And it's not just the way the law is written, it's the way the courts have applied the law, because many, many courts, unfortunately, have come at this from a standpoint of, it's a contract, I'm going to enforce the contract and hold this person to their bargain. Well, the problem there is, not if the bargain is illegal, right? That's the sort of missing link. That's the step that so many courts have missed. And sort of over decades, particularly the past 30 years, it's become sort of non-compete enforcement all the time. Now we're starting to see a sort of trend back in the other direction. But the problem is, from a labor market standpoint, there's been massive collusion and wage suppression. And it's not just in the non-compete space. You also see it in the sort of trade secret space, with companies filing frivolous trade secret lawsuits against everybody. Any competitor who shows up on the scene, the big company, the dominant sort of player in the market, they're going to whack the nascent competitor, the new market entrant, with a bogus theft of trade secrets case. You see it in the trademark context. Did you see Apple? Apple was just beefing with some startup company from Utah that was trying to trademark a pear logo, right? Literally, it's a pear. It's the outline of a pear, and Apple is going at these people and trying to prevent them from trademarking this and saying that it could confuse consumers. That's preposterous. That completely flies in the face of well-established trademark law, but Apple's doing it anyway, right? So what happens to all of these people, whether they get sued for a non-compete agreement, or they get sued for theft of trade secrets, or they get sued for trademark infringement, right? The vast majority of these folks simply cannot afford to hire counsel, because defending a case like this costs an awful lot of money, okay? The folks realize, right, that, so I've had a small law firm for several years, and I've done a tremendous amount of non-compete, trade secret, trademark litigation. And these cases are expensive to litigate and to defend. And we represent, we represent everybody from, C-level executives of publicly traded companies and sort of rainmakers and entrepreneurs and world-renowned surgeons and everybody else. We represent those folks. By the same token, I represent a lot of folks who are poor because, one, I grew up poor, and two, I'm acutely aware of the access to justice problem in America, and it's an issue that I care very deeply about, and I will put my money where my mouth is, and I will go out there and I will represent poor and working and middle class people for free, often at tremendous cost to myself. These cases cost a lot of money, folks. I don't know if people realize, right, that for you to run, any kind of actual legal operation, any kind of a law firm, right? You need to litigate cases like this. You need multiple attorneys, you need support staff, you need Westlaw. I mean, dear God, anybody who runs a law firm knows that Westlaw is utter highway robbery. I mean, it's absurd, the thousands of dollars that law firms pay for Westlaw access every month, and then God forbid somebody clicks on some out of plan documents, and bam, you get hit with a $1,500 out of plan Westlaw charge, right? So these cases cost a lot of money to defend, and most people, they simply cannot afford to pay $100 or $150 or $200 or $250 or $300,000 to aggressively litigate a case like this at a very high level. They can't even afford to pay $2,000 to get, some sort of rack rate bottom feeder, and that's the reality, right? And again, it's going to offend everybody in the profession. It makes me a pariah, but there are bottom feeders out there, right? Who say, oh, just give me a couple $1,000 and, I'll take your case, right? And then it's, oh, give me another $3,000. Oh, give me another $4,000. Oh, give me another $5,000. And they never clearly explain, to these sort of unsophisticated folks, unsophisticated clients that, no, you're posting a retainer or an advance against fees, and even if it's only $3,000, right? Which I see this happen out there. I see these sort of lower tier lawyers, they'll sign a client on, they post a $2,000 or $3,000 retainer, and don't explain to them that that's just an advance against fees, and that there's no way on earth the case is only going to cost $2,000 or $3,000 to litigate. And then they just keep coming back, and these poor unsophisticated clients are like, well, I thought I hired a lawyer for this, and I thought it was going to be $2,000 or $3,000, and now I've made several payments, and I don't have any more money left, and I don't know what I'm going to do. And the lawyer's like, oh, you better sell your house. You better, take out a second mortgage or home equity loan or something so you pay me my fees. And I think that's terrible. I think it's a reflection of a broken legal system and a broken model. And so the question is, what needs to happen to address this? We need to deregulate law. It's a monopoly. It's a cartel, right? Isn't it so interesting, right? That most of the work that I do and most of the issues that I'm working on, right? They all come back to monopolies. They come back to cartels. They come back to people restraining and locking up the market in ways that are improper and bad for consumers and competition, and at the end of the day, society. And there's probably no more glaring example right now in America than the monopoly that state bar associations have on the practice of law. The folks who are against this, they will tell you that we can't deregulate law, and it's imperative that everybody be licensed and admitted and take the bar exam, and go through all these hoops and be subject to all these regulations and have people sort of watching over their shoulders. Well, I'm sorry, I don't think I've read too much of the research and the literature on this. And those concerns simply are not borne out in the actual evidence, right? The bar exam is actually historically, the bar exam was a thing that cropped up in like the 1920s and 30s, right? Prior to that, people would apprentice with law schools sort of arose, in the decades before that, and then the bar exam became formalized. But, back in 1850, people apprenticed and then would go be sworn in a local court, right? There was, there weren't all of these sort of crazy rules and regulations. But at this point, I'm for going even more radical than that, right? I'm for scrapping any kind of licensure or regulation, right? Anybody who wants to provide legal services should be allowed to provide legal services, right? You have paralegals out there, you have legal assistants, you have non-lawyers, you have accountants, whoever it is, right? If these folks can go out into the market and assist people and sell their services and their advice, and likely do so for a fraction of what actual sort of licensed, authorized lawyers do, I see no reason to prevent them from doing so. Because the folks who oppose this, they basically say, well, the quality of legal services would suffer. It'd be so terrible to let these people into the market. Brother, have you seen the quality of some of the legal services that are out there today? Have you seen the sort of sloppy copy and paste work, the incompetence by so many lawyers practicing law in America today? What makes you think that just because you force people to jump through these hoops, that this is going to have any real meaningful impact on establishing a sort of floor of quality and protecting consumers? It absolutely doesn't, because there are so many people in law who do terrible work, who are unethical, who are nefarious, but they're friends with the right people, okay? And so they're politically connected and they're insulated. And those people, have sort of Scott Rothstein, right? Look at that, Scott Rothstein. My goodness, Scott Rothstein was a power broker, major player in the South Florida legal scene, particularly in Fort Lauderdale. And Scott Rothstein was running a massive Ponzi scheme, but that guy knew everybody and he was friends with everybody. And it wasn't until the entire house of cards came falling down and the feds were on him that he finally got thrown out of the profession. But up until that moment, he was running around doing all kinds of nefarious shenanigans, but he was friends with everybody, including some very powerful folks down here. And so he was allowed to sort of thrive and, be a big shot muckety muck in law. But that's how law is, right? You mean to tell me that, given all of this, right, given the sort of existing problems, right, with lawyers and ethics and competence and everything else, that coupled with the absolute inequities of people not having access to justice and people not being able to afford to hire a lawyer and get counsel, right? You mean to tell me that in spite of all these considerations, we should insist that nobody else be allowed to get in and do law and give legal advice and litigate cases? I'm against that. I'm against that, folks. We can't. Insanity is doing the same thing over and over again and expecting different results. And the reality is, I see such a dramatic need for lower cost providers of legal services, whether they're lawyers or non-lawyers, paralegals, legal assistants, whoever it is, right? A clinic made up of graduate students or law students, I do not care. If these folks can render services and help poor and working and middle class people who need representation, I am all for it, because I am one person and I am one person with a small law firm in Fort Lauderdale, and I get every month, I probably get at least 50 calls, emails, inquiries, messages. I probably get at least 50 inquiries from people who desperately need help and simply cannot afford to pay the real cost of providing those services. And I'm not going to charge somebody $100, right, or $300. I'm not going to charge somebody $300 to give them some advice who's indigent, right? I'm not going to charge somebody $300 to give them advice when I know that they are destitute and that it's really a choice between get legal advice or pay the rent, right? What kind of a society is that, where people have to choose between getting legal advice or paying the rent or buying groceries? Especially when they're being sued in some kind of bad faith, frivolous, bogus, non-computer trade secret case, right? This whole regime is just making, in my opinion, these nefarious lawyers money who pursue those types of cases at the expense of poor people who are being prevented from hiring or engaging legal representation because the market's locked up and the state bars have a monopoly. How is that fair? How is that ethical? How is that equitable? How is that the best our society can do? So the bottom line here, folks, is that America has a massive access to justice crisis. And it's not just, in the sort of, criminal law space. It's in the civil and commercial space. And it's particularly in cases where folks are defending themselves against frivolous, bad faith litigation, and particularly against bad faith, non-compete, trade secret, trademark litigation, all of this sort of litigation that is designed to suppress and restrain, to unfairly and illegally suppress and restrain competition. Folks who are faced with defending these types of cases, the vast majority of them simply cannot afford to defend themselves. And that has to stop and that has to change. And the sort of constant refrain of, no, we just have to, keep the system the way it is and people have to do more pro bono work. Well, I do more pro bono work than any lawyer that I know, period, point blank. And the lawyers out there, who do give back and take pro bono cases, there's only so many of them and they can only do so much. So leaving the system the way it is and just relying on lawyers to do more pro bono work, that is unrealistic. That is unrealistic and that is not a solution. The solution is to deregulate law and let anybody in who wants to do the work. Let anybody in who wants to represent folks and advocate for people. And people say, oh, that's so crazy. Oh my God, the quality standards, etc. You realize that in certain arbitrations, you can already hire whoever you want. In certain arbitrations, it's even been held, right? I've even seen it held in the context of the AAA, the American Arbitration Association. I've even seen it held that I think it was like an ex-lawyer or something like that, or a paralegal, who offered to represent people in arbitration. And he obviously got popped by an aggressive state bar, unlicensed practice of law. They went after him. And he was actually found not guilty of anything because it was like, look, he's doing arbitration. That's not practicing law in your legal system. That's arbitration, which has its own sort of rules and regulations, and they can choose who they allow in. And, they allow folks to hire whoever they want to represent themselves. So it's already being done in certain arbitrations. Why can't we do it in court, right? We need to all come together and have a candid and meaningful discussion about access to justice and about deregulating law. Because the reality is these concerns about sort of quality and everything else, they are far outweighed by issues of access and people not being allowed not being able to, obtain counsel to represent them in cases that are potentially devastating and will bankrupt them and leave them even more destitute. And I think in closing, I would say that if you are a lawyer and you are licensed and barred and admitted to practice law, and you have a law degree and you worked in law, if you are a lawyer and you are concerned about competition from non-lawyers, if you are a lawyer and your first thought here is, well, I don't want these non-lawyers coming in because they'll compete with me for my business, well, I think that's too bad. Because as a lawyer with a law degree and all that education and that training and that experience, you darn well should be able to go out in the market and compete for business against non-lawyers and get that business. And if some, person who's a paralegal is able to provide better services than you at a better rate and get that business and keep earning that business, right? Because if they suck, they're going to crash and burn. Word's going to get around, and I think the market will run them out. But if your biggest concern is competing against that non-lawyer, I have to break it to you that maybe you should find another profession. Jonathan Pollard, competition lawyer, Fort Lauderdale, Florida.